Lovely. All right, yes. And so by way of introduction, my name is Mrinalini, and I'm joined here by Joanne. We serve as co-executive editors of the online division of the Columbia Undergraduate Law Review. And we are delighted today to welcome you to Reimagining Gender Justice, a conversation with Ting Ting Cheng at Columbia Law School. Hosted by CULR, or the Columbia Undergraduate Law Review. This is an event that commemorates our journal's annual high school essay contest, which we launched this year in partnership with Ting Ting and the Equal Rights Amendment Project at Columbia Law School, where she serves as director. This event is a moderated discussion followed by an open Q&A session. We will begin by introducing CULR, our wonderful speaker Ting Ting, and our student essay contest winners, before moving into Q&A. We will finally open the floor to your questions. And as I said, please feel free to raise your hand when we call for questions and or to send us the questions during the event via the Zoom chat.
Yes, and just to briefly introduce CULR, especially for our attendees that are not part of the club, we are Columbia's only undergraduate legal publication, as well as one of the first major undergraduate legal publications in the US. And we publish long and short form articles, we host events like this one, and we produce a lot of multimedia legal scholarship. So if you're interested in looking more at CULR's work, or if you're interested in joining in future semesters, you can go to our website, which I will type in the chat right now.
And we are also very excited to be introducing Ting Ting. Ting Ting is a civil rights attorney and activist with experience in gender discrimination litigation, serving as the inaugural director of the Equal Rights Amendment Project at Columbia Law School. Earlier, she was an attorney at the New York City Commission for Human Rights and a public defender and immigration defense attorney. Ting Ting also served as legal director of the 2017 Women's March on Washington and served on the National Organizing Committee of the March. She was a foreign law clerk to 2 justices on the Constitutional Court of South Africa, and we're going to be getting into this a little bit later in the event to talk about Ting Ting's experience in other legal systems and also international models for gender justice. And Ting Ting was also a Fulbright Scholar in South Africa, where she received the Amy Beale Award.
Yeah, thank you so much again, Ting Ting, and we're excited to hear from you later when we go into our moderated Q&A session. The final piece of background we wanted to offer is that every year CULR hosts an annual high school essay contest where we invite students from across the globe to submit their work to us on a legal prompt. And this year, as we've mentioned, we are thrilled to partner with Ting Ting and the ERA project to launch our first ever contest on gender justice. And the prompt basically invited students to write on the extent to which demands for gender justice can be realized in domestic or international legal systems. We've received a record number of submissions on topics ranging from workplace harassment to reproductive rights and beyond in American, international, as well as other national legal systems. And we're so grateful to have some of our award winners present with us today on Zoom to share their theses. And if you're interested in reading the winning essay, which will be introduced shortly, or to see the full list of award winners, you can also visit our website for that. There's a tab titled High School Essay Contest. So now we'll introduce each of the winners. When we sort of say their name and their school affiliation, they'll offer a brief 2 to 3 sentence summary of their paper.
All right, so with that, we're very excited to introduce the winner of this year's essay contest, Carrie Jiang from the Deschen School, whose essay title was Building a Gender Competent International Legal Framework on Sexual Violence. And we will turn it over for a summary of the essay.
Hi, good morning, everyone. My name is Carrie Jiang. You can also call me Carrie. I'm the winner of this year's high school essay contest. And in my essay, I discuss how international laws have omitted sexual violence as a form of gender-based violence and therefore should build gender competence in the international prosecution of sexual violence to protect the rights of women and other vulnerable persons to equality before the law. And more specifically, I argued how the non-consent elements of proving sexual violence ought to be reinterpreted to credit the victim's testimony with veracity. So that's my thesis. Thank you.
Thank you so much. And if you look at the link that Mrinalini dropped in the chat, you should be able to see their wonderful essay. We were truly impressed with this submission and very excited to announce it as our winner. We'll now move to introducing, Elena Prado from the St. Paul School, who will be presenting their thesis.
Hi, everyone. So my name is Elena, and being from Brazil, I chose to write a bit about our national legislation regarding gender justice. And so My thesis is Considering Brazilian Responses to Gender Justice. My essay refers to cases that acted as a catalyst for change in the Brazilian legislation, which now defines feminicide as a crime within our country's penal code. However, these changes reflect a poorly paved road as the nation's progress is motivated by international condemnation, whilst new legal precedents are being set to undermine women's rights. And all of these contributes to our domestic violence rates, which are double the global average.
Thank you so much. It was another fantastic essay. And now we are excited to introduce one of our finalists, Sai Sharan Chettiar from the Global Indian International School.
Yeah, hi. I'm Sai Sharan Chettiar from the Global Indian International School in Singapore, and I based my essay on the powers and limitations of the law in bringing transgender equality into medical care in the US. In this, I analyzed the barriers that prevent people in the transgender community from accessing general healthcare and gender-affirming care, as well as presented legal reparations of my own that could be implemented in overcoming these barriers, while keeping in mind the hurdles that couldn't be tackled through the law alone.
Thank you so much. We're now going to introduce one of our other finalists, Antonia Park from University High School.
Hi, my name is Antonia. I would like to apologize first for my voice because I'm a little bit sick right now. But I'm from University High School in California. And as a Korean American woman, the stories of the comfort women from World War II is an issue that speaks to me personally. And so in my paper, I focused on several cases from the Japanese high courts in which some of the comfort women came forward years after World War II. So basically my thesis was that military violence towards women epitomizes the deeply rooted belief that women do not have greater jurisdiction over their bodies than men, which can be dismantled over time by investing in education that informs younger generations of the injustices that have long oppressed women. Addressing gender inequality by ensuring that it is acknowledged by schools will, over time, dissolve the systems of thought that allow gender inequality to survive in modern society.
Thank you so much, Antonia. It was a fantastic essay. And thank you to all of our wonderful high school essay contest award winners who joined us today and shared their amazing topics. We are now going to move on to the Q&A portion of this event. And Joanne and I are going to start by asking Ting Ting some questions based on the brilliant questions that were posed by our high school essay contest winners who are here with us now. And after that, we will open it up to open Q&A. So I will hand it over to Joanne to ask the first question.
Yeah, so the first question that we have is if you could give us an update about the state of the Equal Rights Amendment today, as well as how we got here. And also, since we introduced you like ourselves, if you'd like to offer an additional introduction, that would also be very appreciated. Thank you so much.
Thanks. So nice to see everyone. I just want to say thank you to the organizers of this event and especially to Joanne and Mrinalini. I just admire you guys so much and I'm so inspired by the work that you do with the Undergraduate Law Review, which is very unique and powerful, I always say. And I want to say congratulations to all the essay contest winners. Your writing and the thought that you put into your essays really give me hope. I mean, I think we're in a pretty dark time in American history. We're heading into these midterms. Things feel very kind of uncertain and lots of changes are unpredictable, especially in light of the last Supreme Court term. You know, for the first time in American history, what the Supreme Court has taken away fundamental rights. And I think that our political system is veering toward more and more extremism. And that form of extremism is kind of manifesting in the policies that we see. So having these essays out there in the world really bring me hope. So thank you for everyone for writing them. Okay, the ERA. So first of all, I'm the director of the Equal Rights Amendment Project. We are actually created pretty recently, over a year and a half ago, to develop strategic legal expertise and guidance on the final ratification of the Equal Rights Amendment to the US Constitution, and then to think broadly about the role of the ERA in redefining gender norms in America and how it would impact gender and sex discrimination laws. Okay, so just very quickly, the US Constitution still does not have explicit gender equality protections. We have one of the oldest constitutions in the world, and unfortunately, at a constitution that's extremely hard to amend. And so we have a document that was written in the 1700s, and we currently have a Supreme Court tasked with interpreting that document, who want to take us back to that time period, especially with, with respect to women's rights and the rights of sexual and gender minorities and all the other fundamental rights that flow out of the Supreme Court cases, starting from Roe and Casey. And so it's really a national embarrassment. We just don't have, there's no comparable democratic constitution in the world that lacks this kind of fundamental equality provision. And it's something that needs to be fixed in order for a democracy to be fully functioning. So in a way, having an ERA, or when we talk about the ERA, it's larger than just gender and sex equality. It's really about the health of the democracy. The ERA has been around for a long time. I think that women have been trying to amend the Constitution since the beginning of the founding of this country, but certainly the ERA itself, which prohibits explicit gender discrimination in the Constitution, was first proposed to the US, to Congress over 100 years ago by Alice Paul and the different movement leaders that succeeded in adding suffrage into the Constitution. So under our Constitution, the rules for amending it are very high. You need 2/3 of both houses of Congress to pass it. And so one can imagine how impossible that seems in this day and age. And you need 3/4 of all 50 states at the legislative level and the state level to pass to ratify the amendment. So that would be 38 states at this point. And the ERA has achieved those constitutional requirements. There are lingering legal issues to do with a timeline that was originally imposed on the ERA as a concession to get it passed in the Senate in the 70s. And unfortunately, that time limit expired after a deadline extension in 1982, and the ERA was actually 3 states short of final ratification. So it's gotten, at that point, it had 35 state ratifications. But, in the last couple of years, 3 states have ratified the ERA in Illinois, Nevada, and in Virginia. So that satisfies all constitutional requirements. That time limit is a congressionally imposed time limit. So it doesn't have anything to do with an Article 5 or constitutional requirement for ratification. Just getting into the nitty gritty, because it's an act of Congress, the theory is that a past Congress can't bind the actions of future Congresses, and a congressional act can be created and can also be removed. So Congress is actively trying to remove that original time limit. The House has actually passed it twice in 2 separate sessions. And it's currently before the Senate, which unfortunately is being held up because, now that we have the election, but also even putting it out for a vote, we have this very anti-democratic feature called the filibuster, in which case you would need 60 votes in support of a proposal in Congress to pass it. So that's where we're at with the ERA. There's also a current lawsuit to challenge the role of the archivist, who's this administrator in the US government that basically records the number of ratifications that come in and then basically rubber stamps it. I mean, I don't mean to reduce this person's role, but this person's role is ultimately administrative, and whether they certify and publish the amendment or not doesn't give the amendment legal effect. But certainly there's a lot of value in symbolism to having a pocket constitution or any kind of like legal text with the ERA listed as the 28th Amendment. So that's the substance of a lawsuit that's now before it was just argued in front of the DC Circuit, which is the level of federal appellate courts right before the Supreme Court. There's congressional action happening. And then, the question about whether the federal ERA is or isn't in the Constitution is still up for debate, although I would say there's a very strong argument that it is in the Constitution itself. But while those legal issues are being resolved, there are 26 state ERAs that are indisputably in the state constitutions that can be used as tools and also as ways to expand equality rights at the state level, and in ways that can really inform how the federal ERA would ultimately be interpreted once there's kind of universal acceptance that it's in the Constitution. So a lot of people haven't heard of the ERA, or a lot of people think that it's something that died in the 70s, or people think that it's a movement of a past generation, but it's actually very much alive. I mean, it's basically in play in all three branches of government. And also it's very much a player in the kind of post-ops world.
Ting Ting, thank you so much. I think we all needed this to get up to speed, and I think now hopefully everyone at the event can appreciate the work that the ERA project is doing and the broader contours of this prompt about reimagining gender justice, because we have this active movement, obviously in the United States, but also I think as we're going to talk about in the international and other national contexts that needs to be actively addressed, particularly given the kind of rollbacks on women's rights and on gender minorities' rights that we're witnessing in this period. We had a question that just takes us away slightly from the kind of policy and law sphere for a second, because our contestants were curious, Ting Ting, to hear a little bit more about you and how you got involved in this work. So I guess what we wanted to ask was, are there particular cases that you worked on or experiences that you've had that inspired or informed your work on the ERA now?
Great question. Well, I will just give a little bit of like my origin story. I am from China. I was born there and I moved to America when I was 9 with my parents. And so I actually didn't really think about the ERA a lot, even when I was in law school. You know, it's just not something that's a subject to like robust debate or taught. So I'm really inspired by everybody here, because there is this there's an important kind of international role that different laws can play to inform American laws. I think our Constitution and our laws are actually a little bit retrograde and need to be informed by other laws and other constitutions that have deeply embedded human rights into their constitutions and, you know, thought deeply about how to deliver that to the people. We don't do that as much in this country. And so I have an international perspective. I think growing up in China has been a really interesting kind of like background perspective. You know, so I had these 2 grandmothers, right? One of my grandmothers is extremely elite. She's grew up in Shanghai, and she was one of the first women in China to earn a law degree. She earned a law degree in 1932, at a time when most women in America were treated like property and certainly were not allowed to enter the legal profession, were not getting law degrees. And then I have another grandmother, equally powerful in her community, but who never gained a formal education, who was a farmer her entire life. And I believe was, you know, in an arranged marriage. You know, she lucked out, like she really got along with my grandfather, but I think when I was really young, that it really kind of occurred to me how forces outside of kind of like what you're in charge with or who you are can dictate your entire role and who you are in your life. And that seemed deeply arbitrary to me, even as like a baby in China. And I think that sense of like this arbitrariness of like assigned roles based on gender or based on other characteristics is totally bogus. And we just can't have a system that perpetuates that, right? And also that favors people above other people based on these arbitrary categories. So I think that that's always been an observation that I had even in a place like China. And then another interesting observation that I have right now is that, you know, in China, I mean, when I was there, that was the era of the one-child policy, which is really a program designed by the Chinese military to as a form of population control. You know, in that context, and really it ended up being sort of like a government sanctioned program of violence against women, essentially. But in that kind of like government structure, they didn't want women to have babies. And here we are today in America, where we have a government structure and laws now that are preventing women from controlling their own reproductive destiny. And it feels like kind of opposite sides of the same cruel coin. It's that when it comes to these like fundamental decisions over your bodily autonomy, and also whether, when, how, if you want to have families, how you want to space it, how you want to participate as a full citizen in democracy, that's just not something that the state should legislate and create policies around, especially by people who have zero expertise or zero knowledge about how women's reproductive rights, bodies function. So back to the ERA, the ERA exists in this like really interesting landscape, I would say. I think like traditional lawyers work on lawsuits and they're always in courts or they think about suing and litigating, but the ERA really exists in kind of a larger political ecosystem. You know, I think the White House can do a lot to advance the perceived legitimacy of the ERA. So can, you know, the Department of Justice, which under the Trump administration issued a very damaging Office of Legal Counsel memo that placed a huge barrier in front of the ERA. And some of the work that we did was write legal analysis and submit work that was cited by the White House and Congress members, and basically play a huge part in getting the Department of Justice to rescind that opinion and to neutralize their previous stance on the barrier to the ERA. We also just publish policy briefs. We think deeply about issues that come up that don't have any answers. You know, the interesting thing about the ERA, whether it's the deadline, whether states who have previously voted to ratify the ERA can now vote to rescind it. These are questions that have no answers in historical practice, and there are no answers that you know, founding people have pointed to. So these are novel questions that we think a lot about, and we try to kind of analyze and try to answer to advance social justice, right? Using the ERA as a tool. I think one of the most interesting things about what's happening at the state level is that there are cases using state ERAs to enhance and expand and protect reproductive rights. So this has happened in New Mexico, in Connecticut. Recently, the ERA project submitted an amicus brief to a case in Pennsylvania, which is brought by a number of abortion providers challenging their ban on Medicaid-funded abortions in the state, because the state has a very old ERA, and the argument is that it violates the state ERA. Medicaid is prohibited from funding abortion for people who cannot afford the procedure otherwise. However, Medicaid covers all sorts of medical procedures for comparable problems that men experience. So it's a very clear-cut case of sex discrimination, is that when you have a policy where Medicaid does not apply to people explicitly because of the fact that they have uteruses, right? That's like squarely sex discrimination. And then there's the other question of like, when you have these policies that basically are designed to perpetuate a stereotype of the role of women in society, the stereotype that women belong in the private sphere, belong in the house to, you know, have babies and to raise children and to be caregivers, rather than belonging in kind of like traditionally a male sphere of kind of like politics and education and the, you know, wage labor economy. That's based on a stereotype because there's really no other justification for it. That's grounded in reality or science or, you know, anything else. And so that kind of stereotyping, as the Supreme Court has spoken, and as the late Justice Ruth Bader Ginsburg has written eloquently about, is invidious, and it is, you know, not allowed by the Constitution or by any kind of state constitutional equality provisions like an ERA. So we heard oral arguments in the Pennsylvania case this week and issued another kind of explainer about that case. And let's see, Utah has one of the oldest ERAs in the country. It was passed along with its original constitution. And that ERA in the state has been used to basically stop its current abortion ban. So people in Utah who can access abortions right now, it's because of their state ERA. So I think there are lots of really interesting ways to use ERAs at this point, especially at the state level. And we don't have to follow current existing laws. We don't have to say, although a lot of states do this, a lot of states interpret their state constitutions in the way that the federal constitution is interpreted, but they don't have to do that. They can actually provide way more protections. They can interpret their state ERAs in a much more expansive way than obviously the way that the federal constitution is currently being interpreted by the Supreme Court. And I think that's really exciting. It's a moment where it's kind of like, let's reimagine what we need and let's come up with some real tools to help people.
Yeah, thank you so much. I think both it's really fascinating and inspiring to hear about your background. And also, I think the point that you made about the state courts and the state legislatures, like, is especially timely, I guess, because I feel like a lot of attention is being placed on the states, both in a negative and a positive light. So it's really interesting to hear about the role that state ERAs are playing in advancing justice.
Oh, and I have to add that there's a current movement, sorry to interrupt you, Joanne. I have to add that there's a current movement to amend state constitutions, which is super exciting. You know, it's basically impossible to amend the federal constitution. Joe Lepore just wrote this article about that in the New Yorker, and I saw on Instagram that they wrote kind of like really interesting statistics. I'll share them with you. In the first 15 years of this country's founding, so 1789 to 1804, in 15 years, the Constitution was amended 12 times. Great. And then in the ensuing 217 years, from 1805 to 2022, today, it's only been amended 15 times. And in the last year, since 1971, it's been amended 1 time. And that amendment was proposed by James Madison, who is a founding father, slave owner of this country. And that amendment is over 200 years old. It's called the Madison Amendment. And it doesn't really matter in terms of social policy in this country. It governs congressional pay raises. And so one wonders why there's even a time limit on something like the ERA, which has so much positive social impact, right? Oh, and then at the state level, so Nevada's in the process of basically adding an ERA to the state constitution right now. Voters are going to vote on it very soon. And it's a very inclusive ERA. It goes beyond protecting gender and sexuality to race and disability and immigration status and a lot of different things. Age. New York is in the process of doing the same thing, as long as it just passed a very inclusive ERA, even more so than Nevada. It also protects reproductive rights in like 3 different ways: pregnancy outcomes, reproductive health, abortion. And it will be on the ballot in 2024, assuming it passes the second time, which is a requirement in the state. And then 3 other states are actively trying to amend their constitutions in Vermont, Maine, and Minnesota. So that's really exciting and unprecedented.
Yeah, for sure. And I know California also has a ballot measure, not specifically, I think, an ERA, but about reproductive freedom. But I guess in light of all of the sort of frustrating things we've talked about, and I think a lot of our contestants also gestured at this in their essays, in light of a lot of the recent step backwards, like obviously the Dobbs decision, what do you think next steps might look like for achieving gender equality through the law so that progress is sustainable? And I guess sort of the corollary to this question is if you think we can still rely on our existing legal institutions to provide this kind of substantive equality, and if not, if there maybe are actors beyond the state that can help implement these models of equality.
Okay, lots of questions here. What I love is that this is a moment where we can really interrogate our existing legal systems. It is what it is, but it's a system that was kind of broken from the beginning, and it needs to be fixed in a major way. But certainly when we look at something like the 14th Amendment, the way that it's been interpreted right now is very formal and kind of based on classifications, in the sense that the Supreme Court has taken a stance where equality to them means just formal, meaning if I get an apple, you get an apple. And that in order to adjudicate whether somebody's been discriminated on based on different categories, they cannot look at external forces, right? And so they are completely ignoring the reasons why people are not equal in society to begin with. And that is not going to fix inequality in America. So that kind of formal approach, I think, oftentimes has been used as a tool to undermine equality in the context of affirmative action, or most recently, President Biden passed a COVID infrastructure bill. And in it, he said that women and minority-owned businesses who have historically faced inequality and marginalization, lack of resources, and structural barriers to attaining, and to having these businesses and to keeping them. they would get their stimulus checks a little quicker. It just would be expedited. It's not a larger amount, nothing else. They just would get it expedited. That provision of the infrastructure bill was then challenged and went up to the Sixth Circuit, which is a federal appellate court right underneath the Supreme Court. And unfortunately, that provision was struck down because it violates the 14th Amendment, because under that judge's kind of formalistic application of 14th Amendment, you can't create laws. The government can't create laws that favors one group over the other, right? It's just, we're all the same, let's move forward. But how can that be when we come from a system of deep inequality and entrenched systemic, right, marginalization of certain groups of people, so that we need laws? And other countries do this. Other countries are very sensitive to the history as a way of paving a path toward equality for different groups. So we need something different and we need something better. And that's what the ERA is for. I don't think the ERA, I don't know if it's all going to be worth it. If all we're going to do is just basically get a 14th Amendment for gender, we need something broader than that. And we need something that utilizes, as you say, substantive equality, which is very different than how the courts in America interpret equality provisions. And that's something that's been utilized and applied in other contexts like South Africa, like other newly emerging democracies, in ways that have been really effective. I think that that's the path forward for sure. And also you all, everyone on this call, you are all deeply engaged, right? And this is your legacy, this is your history. And I certainly hope that, you will have more power than me, you'll have more individual rights than me, and you'll have more tools to fight for not only your own rights, but the rights of everybody who suffer from inequality. And so I think that the path forward is also, how you guys see yourselves in this movement, and how you guys kind of engage in civic participation in this moment.
Thank you so much. And we have one last question before we open it up. And it's something that relates directly to something you've been alluding to in this discussion, which is thinking about other national and international models for gender justice. So you've talked about this model of substantive equality. Could you maybe expand on that a little bit further for everyone in our audience? What are these models for gender justice that you see working better in other countries than the model in the United States? What can the US possibly borrow from these models and or from broader international models for gender justice?
Well, I mean, to start, there's this requirement in the US of that discrimination be intentional for it to even be subject to scrutiny by the courts. So that's just really hard. That's a hard bar to set in terms of tackling actual inequality and actual discrimination. That means that for a government policy to be even scrutinized, right, as something that might violate the 14th Amendment or violate state equality acts, it has to, on its face, be worded in a way that's intentionally discriminatory. Most laws don't do that anymore. The courts are not going to look at the impact or the effect of a law. So even if a law is neutral on its face, if it has a discriminatory impact, it's not going to violate the 14th Amendment. I think that that's a problem, especially as we know now how powerful, bias is, both implicit individually and also within systems, right? And also we've inherited a system that's kind of rigged against certain people. So that's something that needs to change and that other jurisdictions can inform on. And then in terms of substantive equality, we don't have that in the Constitution. We protect against, we have kind of like protections for political rights, although, at this point with the erosion of voting rights, I question how many political rights are being protected right now. But, we don't have kind of like socioeconomic rights in our constitution, like other countries like South Africa. So that means the right to healthcare, the right to education, the right to pursue your livelihood, the right to live with dignity. Those are actually legal concepts. The right to dignity is a legal concept that other courts and other constitutions actually adjudicate. We just don't even have that. We also don't really adopt international human rights standards. We are not a signatory to CEDAW. We are kind of very much I don't know, shrouded in this concept of like American exceptionalism, where we don't want to sign on to these international instruments that are just broadly accepted in the world and would help everybody. So I think like having the US acknowledge international instruments passed by the UN that protect fundamental rights based on gender or the rights of children, right, or trafficking, I think that's really important. And then also looking at other jurisdictions to expand socioeconomic rights that we just don't do in this country would be really important, especially in a post-pandemic moment when we're suffering from such an economic crisis.
Ting Ting, thank you so much. And at this point, we are excited to be opening things up to questions. But before we do that, we also realize we are joined by our high school essay contest runner-up on the Zoom. And so before we go on to the last part of the Q&A, we want to invite Lauren Mukovitz, who was our runner-up, to introduce themselves. The title of Lauren's essay was Women as Equals, the Application of the Equal Protections Clause in Current Discussions Concerning Abortion and Pregnancy, something that I think is highly relevant to what we have just been discussing. So Lauren, if you'd like to briefly summarize your essay, and then we'll move on to the open part of the Q&A.
Hi, my name is Lauren. I was the runner-up. My essay specifically focused on the leaked and now final Dobbs v. Jackson Women's Health Organization majority opinion. I focused on a paragraph in the introduction by Justice Alito where he stated that pregnancy is not as a sex-based qualification is not grounded in precedent. And what I did was I used the amicus briefs that were submitted in the Dobbs case, as well as some other Supreme Court cases, such as Nevada v. Hibbs, United States v. Virginia, Gettelig v. IAO, and Roe v. Wade, to show that that statement lacked the necessary nuance, and that in order for women to be done right by the law in the 14th Amendment, that if we are going to consider still using classifications in order to show that people need to have equal rights, essentially, that women need to have pregnancy considered as a sex-based qualification.
Thank you so much. And as Renalini said, it was a pleasure to read your essay. So we're now going to open up the floor. I'll first address the question that was asked by Julia much earlier about the article regarding the history of amending the Constitution. Renalini and I will reach out to Ting Ting about what that article is, and we'll send that out to everyone in a follow-up email. So just going through some of the questions in the chat, people are also welcome to raise their hands if they'd like to ask their question out loud. But the first question from Corinna is, how do you imagine this alternative in our polarized climate when history, truth, and fact are treated as mercurial? For instance, what's stopping neo-Nazis from claiming they need more protections?
Is this a question for me or for the?
Yeah, it was a question for you. Sorry.
So sorry. Okay. Can you say the question again? So I was listening.
Yeah.
I was thinking about the reading list that I'm going to create for you guys. Sorry.
That sounds lovely. Yeah, it's the first question that's in the chat. I think there's a couple of things going on in the chat right now, but the question was, how do you imagine this alternative in our polarized climate when history, truth, and fact are treated as mercurial? For example, Corinna asks, what's stopping neo-Nazis from claiming they need more protections? And I think this is in reference to what you were saying about like future models for substantive equality.
Okay, so I mean, I'm curious to hear what you all think about this question as well. This is a great question. I think that what makes me feel concerned is that I think that we're in an era that feels openly like fascism to me. I'm not being dramatic, but let me just say that, you know, the function of lawmaking and the function of representatives in Congress and at the state level is to represent the people in a democracy, is to answer to constituents and to think through policies that benefit society, right? Benefit the community. I don't see that happening at all. I see just politicians trying to hold on to power and to consolidate power, and using the political system and using polarization in particular to hold on to their power. That is to say, they are using their role as a politician not to create policies to benefit their communities and to benefit the democracy at large. They're using it just to create power. And a really effective way of doing that is to create confusion and to openly repudiate facts and history and knowledge, right? And also tap into kind of people's fears. So what can we do about that? One of the things that is really interesting about the kind of constitutional amendment process and the history is that, so every single amendment to the Constitution has happened in kind of very bizarre ways. And when you talk to legal historians and political scientists, like no one really has, we can't look to Article 5. Like the language itself is too broad. It's just sort of like Congress does this, the states do this, done. But none of the amendments were so clean like that, right? It just, nothing happened so cleanly like that. And so nobody really can agree on like what is the moment, the constitutional moment when something's like accepted in the Constitution, other than the fact of like, I would put it maybe like a fake it until you make it thing, sort of like if everyone talks about it, if we can all agree that this is an important feature that is in the Constitution and can now be interpreted, then there's buy-in from everybody. So we all have a part to play in that. Like we all need to kind of talk about the ERA. We all need to talk about substantive equality. We all need to talk about the fact that when you take away fundamental rights, either based on gender or race or any other protected category, that you're really reducing a person's role in the democracy and you're rendering them like less than a full citizen. And so, and then we also need to talk about how we can change it in our local areas. So, you know, no matter what state you live in, you can engage in the process and figure out what does your state constitution need? Does your state need to ratify the federal ERA? Can you hold a town hall to talk about substantive equality? Can you engage people? Can you create, educational curricula? Can you create essay contests? Can you create an undergraduate law review? You know, all the things that everyone on this call are actively engaged in, I think just needs to happen times a billion in this country.
Yes, I think Renalini and I definitely agree. And I do think that there is some hope in the fact that, as you said earlier, at the state level, there do seem to be attempts to sort of like recognize the need for substantive equality, recognize structural injustices. Like I'm thinking about a case at the Washington Supreme Court level that was not explicitly about gender justice. It was about like child welfare systems, but that a majority opinion did talk about like how Black and Brown communities have been historically oppressed by the child welfare system, and like seeing a court explicitly recognize that was, for at least myself, like some form of optimism, even though there's definitely a lot more work to be done. Julia also asks for recommendations on the subject of the ERA. I think you touched on that briefly about how you're planning on maybe creating a list, which we would all definitely appreciate, at least I and Renalini would, as well as some of these students. So I'll skip that question for now, but Michelle has a question asking, how would you answer the argument that the ERA would force women to also enlist in the military? And also a separate question about how we would define the right to dignity.
What's the argument? I mean, who's making the argument? Is anyone, is there a law? There's no law. No one's making that argument. No one, I don't think I don't think anyone has even ever proposed that law. You know, I think that we can get into all of these, we can get into these like intellectual dialogues about the what ifs, and in fact, those are the kind of the tactics that were used in the 70s to slow down the movement and to basically defeat it in that moment. When Congress first approved the ERA by overwhelming bipartisan support in 1972 and sent it to the states, people thought it was a self-fulfilling prophecy. Like in the first year that it was first proposed to Congress, 30 states passed it. 30 states ratified the ERA in 1 year. That's incredible. And then there was a backlash, and part of the backlash is, this very kind of concerted effort to make it out to be a very scary thing, right? It's like women are going to have to be in the military and they're going to have same-sex bathrooms. And, there's going to be, same-sex couples are going to be able to get married. And it's like, well, even without the ERA, all of those things have come to pass. And I think it's benefited everyone and also the society. And it really advanced like the social kind of like, social justice in this country. So I think it's a positive thing. I don't, I don't know how to answer that question. It's like, it's really not on the table, and nobody has ever proposed that kind of legislation, you know? I think, again, it's not about pure equality. You know, at that time too, the fear was this idea of like, well, a lot of women at that time in the 70s were in this kind of like traditional family unit, where it's like the husband was the person who was out in the wage labor market, and the woman was at home in the domestic sphere taking care of the family. And so she completely relied on his income. And so what would the ERA do? Would the ERA make her go to work? Would the ERA, you know, if they got a divorce, would the ERA force split custody? It's just not a tool that creates formal equality. It hasn't been defined, you know, and it doesn't make sense to me. It's sort of like, it's a fundamental principle in the Constitution. Constitutional amendments, after they're added, become defined by the people. It's a populist, it's a democratic process by states, by legislation, by hearings. And I think that, again, it's an opportunity for us to define it in a way that advances social causes, rather than kind of litigate these kind of like tactical, like black and white rules to use to scare people out of social progress, right?
Yes, for sure. We definitely agree. And thank you, Michelle, for like bringing us back to this conversation about the importance of like differentiating formal equality from substantive equality, because I think that is really relevant. Corinna, I think, has their hand up. So if you'd like to ask maybe a question, a follow-up, just make sure to keep it short since we are running towards the end of the session.
Yeah, first of all, thank you so much. This is so interesting. I was just wondering, so in terms of state ERAs, if we do move towards this idea of substantive equality in these ERAs, when we have, so like Michelle suggested, increasing the level of actual democracy, but if we're in this state of sort of pseudo-fascism, how would just something like substantive equality, can that become weaponized as a legal framework? Do you see a fear for that, or do you think that the framework itself mitigates that potential risk?
These are great questions. I mean, these are important questions too. I want to just acknowledge that Michelle's asking kind of the tough questions and the questions that people have in their mind. I mean, can you give me an example of what you mean? Like how would it be weaponized?
Yeah, I mean, I guess just in terms of things like, you know, if you're in...
Oh, things like fetal personhood?
Yeah, things like that. Or things like trying to increase gerrymandering in some weird way of like, our voting block and our voting rights are being restricted and we're not being counted enough. Yeah, but like fetal personhood is a great example.
I'm really concerned about the fetal personhood stuff. Like I've been hearing about it for a while now, and you know, it's like anything else, right? Even with Dobbs, for a long time, everybody was like, "Well, that's never going to happen," right? And even now, like the specter of, you know, a nationwide ban on abortion, depending on Congress, everyone's like, "That's never going to happen." And I was like, I don't know. I don't think I'm in the business of declaring something's never going to happen. I'm really fearful of that, but I think that when the time comes, there has to be a very concerted legal effort from the academy, from advocates, from impacted people to really push against that. Like there has to, I mean, this is movement work, you know, there has to be an effort to push against all of this stuff. Like we basically have to fight for our rights. We can't just sit here and assume that it's going to be granted to us, because it is being taken away. So that's kind of a broad answer to your question. I mean, I have some like specific ideas of what I would do if I was leading that kind of like pushback. There's this idea of the right is incredibly good at long-term strategies, and that's how we got here, is that they had this, you know, 50-year plan, they had a 30-year plan, 20-year plan to dismantle the right to abortion, and they're not stopping here. They're, you know, thank you, Clarence Thomas, for saying stuff that nobody else is willing to say but is thinking, which is what else is next? Marriage equality, you know, other LGBTQ rights, maybe even interracial marriage, contraception, you know, same-sex intimacy, all of these things the Supreme Court has signaled is on the chopping block. And so what is our long-term strategy? I like this idea of my friend Kate Kelly just said it recently, you know, she's like, well, if you amend the Constitution, it's in there forever. It's going to outlive anybody who's a fascist or anybody who's like incredibly, you know, like motivated to defeat the rights of, you know, minorities or the marginalized people. So there's that. But then there's also kind of a longer term kind of like offensive strategy that we all need to develop. I think we're just all exhausted and taken over by playing defense. And part of the defense is doing that kind of thing of like responding to the what ifs or responding to these like crazy scenarios where you're like, oh my God, I don't know what to do. How would we then legally and use reason respond to this? But really, it's about power. It's really about, you know, people who want to achieve a certain result and then using law to get that result and not really kind of like observing the rule of law and building up the rule of law to benefit everybody. So that's where we're at right now. So for me, it's kind of like one way to respond is to think long-term and to think about making sure that we protect the rule of law, because I think with the other side, they are just do not care about that at all. It's all about achieving an end, right? And using whatever they want, whatever tools they can get, and also consolidating power. They're able to do this because they've consolidated power. And the thing with the ERA too is that it's not just superficial. You know, it's not like with the ERA, there's just should be more like diversity and inclusion officers in all businesses. How do people have power? How do women, how do sexual minorities have actual power, not just be empowered under the law is the main question.
Ting Ting, thank you so much. And thank you to our wonderful audience members for these questions, which have really got at, I think, some of the key themes we wanted to highlight in this discussion quite brilliantly. We are now going to have to wrap up the open Q&A because we are running short of time. But before we ended, Ting Ting, we wanted to ask you one question that has come up from our audience members in their kind of form responses when they were RSVPing. And it's definitely something that we think will resonate with a lot of people on this call, which is that how can our attendees, many of whom have expressed an interest in gender justice, support the ERA project's work and this cause more broadly? Are there current ways, particularly with regard to Columbia and Barnard undergrads who are joining us here, for people to get involved, to follow the project's research, and to kind of learn more about the themes that you've discussed with us?
Yeah, I mean, I think that this is a really critical moment, and this is I see this gathering as kind of an opportunity for a call to action. You know, I think that people we all have so many resources. You all are so brilliant, and you know, I wouldn't want this event to just kind of be a coming together and then we disperse and we don't really think about it that deeply anymore. I'd like to think that this is like
All right, we seem to have lost Ting Ting on the Zoom briefly. I think the video is frozen. But as soon as she is back, we will get back to this. Let's see. Okay,
I think she might have dropped off,
yeah.
But hopefully she's coming back. And
yeah. And in the meantime, just to address something that some of you have asked us about, we will be sending a follow-up email after the event, which shares the recording. So you're welcome to take a look at that and share that with anyone else who might be interested. And we also will sort of pick Ting Ting's brain for article and book recommendations. So anyone who's interested in following up on some of the things we've discussed today is then welcome to kind of go ahead and, you know, read more about them. But yeah, we'll just hang on the Zoom call for another few minutes to see if Ting Ting is able to rejoin us. I think she's having a few internet issues.
I just wanted to say thank you so much for this meeting. This meeting was like actually really interesting. And I actually came into this thinking like, oh, we're just gonna hear all the stuff that I learned about the ERA already, but like talking about the state's constitutions, what they're doing, and talking about like what's happening right now, that was actually really interesting as well.
yeah, we're really glad to hear that. And I think at least on our end, it was really interesting to be able to get really into the details of what's going on and like how we can understand it in the context of our political climate, but also in the context of the ERA's history. So yeah, I'm really glad that it was enriching for everyone here. It was definitely enriching for me.
And also in the meantime, I will just drop in the chat the link to the Equal Rights Amendment Project at Columbia Law School, which Ting Ting directs. And this site will have some interesting policy briefs that anyone interested can take a look at, which kind of follows up on some of the issues Ting Ting has been discussing today. Also just has some good resources that we're continuing to kind of build up. And so it might be something to follow if you want to kind of keep up with the work that Ting Ting is doing. We'll wait for just another second to see if Ting Ting can rejoin us, but otherwise we won't keep you all too late.
Yes, Julia, did you have a question?
Hi, everyone. I was just curious because I was wondering how many people here are in high school right now, because everyone is so well read and so educated, and this is so exciting to meet so many younger people. But I'm a junior in high school, and I was just wondering how many of you all are in high school right now.
Yeah, so we invited everyone who participated in the high school essay contest to join. So I think just based on the RSVPs, about a fourth of the people that are here or were here earlier in the meeting are members of or people who entered in that contest, as well as, of course, the wonderful presenters who won an award in our contest are also high schoolers. I think we'll probably wrap up in this case and we'll reach back out with Ting Ting's answer to the last question, but thank you all so much for coming, for participating. Again, so much gratitude towards our high school presenters for sharing your wonderful theses with us, and it's so great to be able to see your faces. But yeah, thank you so much, and we hope to be able to continue to engage with you all on gender justice in the future. And we'll also hang around if you had additional questions for me and Renalini.
Julia, can I respond to you really fast?
Go for it, yeah.
I mean, I'm a junior in college, so we all feel like this, and the fact that high schoolers are engaging with material at this level, I could have never, for real. And I don't mean that as just a little saying that everyone says. For real, the fact that you're just here and attempting to engage with this and really engaging with it, these papers, when I read these papers, I was like, oh, they're college students. I legitimately thought that. Don't worry. We all feel like that in college. Don't worry about it at all.
But yes, you are free to go unless you have a question for us. Thank you all so much.
Everyone, and yes, thank you. And shout out to all of our amazing presenters. You guys were fantastic.
Thank you so much.
Thank you.
Bye.
Thank you.
Thank you so much.
Also, I had one more quick question. I don't want to keep you guys too long.
No worries.
Are you guys Columbia students or Barnard or both?
We're both Columbia, yeah.
Oh, amazing. So I'm really interested in applying for, I haven't decided between Columbia or Barnard yet, but I know there's a big partnership. What is some of your best advice for